Artificial Intelligence Law and Justice course, session 37, topic AI, Law, Justice and Innovation. Let us do a recap of the previous session, that was on AI and Constitution. In the second session on AI and Constitution, we dwelt upon further on AI's implications for Constitution, constitutional democracy. We also discussed about interpreting Constitution through AI systems and emergence of new ideas like digital constitution. So we stopped with that, with the idea of AI and Constitution. But in this course, we also need to look into the crucial issues in AI, law, justice and innovation, because ultimately AI is a matter of innovation, and then how innovation will impact law and justice is the broad theme of the course. So we can begin with the overview of AI in the legal profession. Actually, the legal profession, the engagement with AI has started much earlier than what we would assume, because even as early as 1960s, there were articles on how AI could be used to help the judges, and then there were a lot of articles which were written in those era of artificial intelligence on AI, using AI as an expert system in law. So over the past 60 or 70 years, 60 years at least, we have a lot of work on AI, law, justice and innovation, focusing upon the context of the technological developments, how they could be applied and all. But these things became more important or more relevant in the last 15 years or so on account of developments in the AI. So now the generative AI is a major dominant one in the legal field. We all know about it, but this is not as advanced as the HAL 9000 from 2001 SPSWC, and it is not as human as now, so it is more in the initial stages now. But AI's evolution is in a staggering rapid speed now. So when technology involves so much, it is very difficult to really predict the impact on justice. For example, Bing's AI search resulted in the change in 3 months, in the sense that it was unanticipated that it would become so easily available. And then the current use in online dispute resolution platforms, human factors assist in pre-trial assessments, in the sense that human facilitators use the AI-based online dispute resolution to look at the pre-trial settlements so that the facilitators are available in chat space or via email. So the potential for generating AI to do real facilitation in ODR platforms is very huge. Or in other words, some of the unanticipated consequences of generative AI becoming more capability are already there, in the sense that we can sense them. Now, online use of court line online disputes resolution for high volume civil disputes will be a very positive welcome development, because these settlements are parallel to the on-court adjacent, and then we right now need human facilitators for online settlement pre-trial. But generative AI with its own capacities can facilitate real-time settlement, saving on human labor cost. AI again can really narrow down the settlement space more accurately, quickly than citizen mediators, because it has got a better grasp over the disputes, the precedents, what are the matters that are contentious. It can come up with quick solutions, whereas human mediators will have to really debate, think about it, and then have also to write down certain things, and then have to cross-check things. Whereas AI can do certain things in a much more faster way. And when AI does it, it can result in a better situation where the conflict is already avoided or litigation is avoided. And then AI can address some difficult issues, identify them much before the trial or the suits are filed or the trial starts. More importantly, it can also try to convince the parties to come together for fair agreements in matters like residential leases and to prevent disputes. Or AI can play a major role when we think in terms of dispute settlement. It can do a much more better role when we do it in the pre-trial stage itself. More importantly, it can also help the parties to become more aware, get educated on their problems and solutions, and then look at them objectively through AI eyes, and then help them to understand it. So without a human AI person intervening, AI can try to avoid litigation and conflict. And if this is done, the major issue of backlog of cases or cases piling up on a day-to-day basis on account of new cases can be avoided. And AI can provide accurate legal information. It can improve the efficiency of the lawyers and judges. It can provide better tools for risk assessment. It can also give more actionable advice than giving a note that runs to pages and pages. For unrepresented litigants who don't have access to justice because they are unable to travel or they are not able to really pay the fees for an advocate, AI tools can be much more effective. This we have seen in the earlier sessions also. And in cases where unemployment benefits, social security benefits, social welfare benefits, maternity benefits, or addressing eviction suits, or consumers, or medical debt, or medical insurance claims, and then family disputes, AI can play a very proactive role. And many of the underrepresented litigants or litigants who really can't afford to pay for an advocate or undergo a costly, time-consuming legal process will find AI tools very handy for it. So the potential of AI, generative AI in legal sphere is yet to be fully explored or even understood. But generative AI tools can really make a huge difference if these people who otherwise don't have access are able to really access, handle those tools and then benefit immensely from it. Often, many people who are reluctant to come to court will have lots of reasons which may find silly to some of us, but they may be genuine from their own perspective. For example, many people are not very comfortable with electronic document filing, or they're not very comfortable with coming to meet an advocate or go to a court because they are burdened with family burdens or they don't have facilities that can take care of their routine work so that they can spend some time in attending to these legal matters. So in such cases, AI tools which can interact with them will be much more beneficial to them. And generative AI can be a technology that can help people to understand as to why they are not able to reach out to the judicial process. So the reasons for identifying can be noticed, and generating AI can also help us to identify why people are not so tech savvy or are not so tech friendly or why they are not interested in using technology. So the factors that delay the process, people reluctant to use various tools including AI tools can be identified. In other words, when we can streamline court experience or interaction with the court through AI tools, we can streamline the court experience, we can enhance court-based litigation and then court adjustment efforts. And then for many of those who don't want to get lost into the legal shuffle, this will be very helpful. More importantly, the current problem is that lots of legal information is not easily accessible. It is accessible in books and volumes, it is accessible in bound volumes, and then lots of legal service authorities are trying to help people, but access to legal information is not easily available now, particularly for those who really need it most. So AI tools can democratize access to legal information. AI tools, consumer-facing tools can answer queries, can come up with suitable answers or at least tell people where they should look for information. More importantly, they can generate preliminary level legal documents so that they know that this is the real issue which they want to address through courts. And they can offer guidance and advice. Of course, there are limitations with which we should be familiar with, but still, in the preliminary stage, when advocates are there, but then the litigants are not able to access them, or litigants have some genuine doubts as to whether the advocate will be really able to help them, AI tools can act as good intermediaries to bridge the gap. For people without legal access, this will be something where people can really get access to these tools as a preliminary experience with them. So when law can be demanded and then law can be accessed by litigants through digital devices, enables reduction digital divide, also enables better access to legal tools. Major problem with legal tools, legal system and then acts text is that they are too complicated for a normal person to understand because they are written in legalese which normal person will not be able to decipher. But generative AI can really simplify these because it can help people to come up with summaries which people can easily, quickly understand. And for people who want to represent themselves in the court, for either they cannot afford to go to a lawyer or they think they can better talk to the address the court by explaining their own cases, generative AI tools will be really helpful because it can help them to understand why their case may result in dismissal. By looking at the previous cases, it will also help them to put up arguments coherently in a better way. It will also help them to understand the process rules in the court and then tackle them efficiently. At a macro level, AI tools can identify patterns which even intelligent lawyers may not be able to identify. So it can help in many ways by streamlining procedural rules, by improving the legal arguments of the litigants, by enhancing legal decisions by pattern deduction, and then thereby bring in more transparency and accountability to the overall legal process. Then it can rationalize complex legal systems by determining the judicial indicators and by going through large data sets, it can come up with patterns, it can set better standards, and then it can help in defining recidivism metrics. The recidivism metrics are the ones that set the parameters for bail cases where the potential of the applicant to commit a crime again or to jump the bail are taken into account. Generative AI can really help us in redefining these metrics which are often used in AI-based tools to assess claims for bail or to relieve people or to release people on parole. Then, if we talk of a community-based legal assistance legal service, generative AI tools can help them to meet those goals in a much more efficient way. So when these things are done with the help of AI, judicial oversight efficiency can be improved, resource allocation can be optimized. But stakeholders should be sensitized and educated enough so that they are comfortable with using generative AI tools, outputs, and then take them as reliable evidence or documents they can use to further their legal matters. But for the legal system, this entails one major change, which is that it requires the willingness to move towards data-based changes rather than to be relied upon solely upon text-based ones. So we need to bring in transparency in the whole process. When due process reigns in notice and opportunity to be heard, the same thing should be available in AI as well. But we also know that AI systems lack transparency and there's a major bottleneck. So we need to develop prototypes which have target populations as the clients or as the clients who could test these prototypes and then identify the lack of transparency matters and then make them better. So what we are talking here is developing AI tools that could be used as a test bed so that their transparency can be enhanced by interacting with different target groups, by interacting with different scenarios involving the different target groups so that AI tools transparency can be made much better. In other words, create a human in the loop system where human oversight plays a major important role. Particularly in high volume, high stake civil litigation, AI tools efficiency is a matter that should be appreciated, but having a human in the loop system where human oversight is also part of the system is more important. Bringing human oversight will result in timely, efficient interventions. More importantly, if the AI decisions are not the ones that could go wrong, or there is some specific issues which have been identified by the litigant, but the litigant is not the one who could take the decision, human in the loop can switch over or take over that role and then put that system to stop and then identify what needs to be done next. But then involving human oversight also means understanding the level of risk and then what are the potential implications of the delay in involving the human in the loop or the human oversight. More importantly, what would happen if the human in the loop or the human oversight by chance misses certain things and then okay certain things by an explicit understanding that things may not go wrong when AI tools are there. So the limitation of the human oversight should also be factored in the system. For all this, we would need impact assessments of the AI models. First way, ensure that expected outcomes align with the observed outcomes. For example, if it is observed in earlier cases that certain instances where the process is very rigid and people who are not able to meet the process is rigidity or not able to get the claims or their petitions are dismissed, the AI model's outcome should be something that is very similar to that. It cannot be something that runs contrary, or it cannot be an outcome where 50% of the people who are unable to make the rigidity of the process are able to get the benefit. More importantly, we need to incorporate new data and the new norms into the system. Trying to reduce the bias over this period of time will also be useful. Then the system's expectations should be carefully calibrated in the sense that who are the beneficiaries, who are the target audience, and then how the system will work, what sort of claims the system will be able to process. These things should be factored in. Then identify the potential problems before they cause harm. For example, in UK, NEDA came up with a chatbot to help the litigants. The chatbot worked well in the initial stages, but after a few trials or when put to practice, it came up with some answers or its functioning was not something that was anticipated. So when use of legal tools, particularly chatbots, the potential problem should be tried to understood through extensive trials and only then they should be put to trial. They should be put to practice. Then the system should be as transparent as possible, although 100% transparency is an ideal which can never be met in the real time sequences. So how do we build trust? How do we build understanding? And more impact, how do we ensure that people you do use the systems in a responsible way? So clear guidelines should be provided, responsible use should be stressed, and more importantly, people should be educated. If there are some risks, the system should be able to help people to mitigate that risk either by bringing human oversight or by ensuring that the risk which the participants may face is obviated through other means. So transparency and then effective responsible use, building trust and understanding are important. But what exactly are we talking of when we say we evaluate the system? What are the parameters? Because when we talked of responsible AI, we listed about some 7 or 8 parameters. But when we want to evaluate, we cannot evaluate system on about 7 or 8 parameters alone and then also on other parameters. So we need to know what exactly are the parameters or the key parameters that should guide in evaluation. And from a user perspective, inclusivity is very important so that the system is meant or developed for taking into account the needs of a wide variety of users. So inclusivity and transparency can be the major criteria for evaluation. And then for self-represented targets, you should look at what is the win rate. These are for the potential scope for them to win in a case if they represent by themselves. And assess how much time the system takes to dispose of the cases. Is it sufficient enough or does it dispose of cases in a much more quicker manner, although the transparency and then inclusivity are not compromised. Then in some circumstances it will be very difficult to predict really as to what's the right choice. So the outcome variable may be very different or very varied. So the system should reflect the values and needs of the community for which the tool is being developed, rather than identifying the ideal outcome or the ideal choice which the tool will develop, which the tool will give as an output. So what should be evaluated should be depending upon the community's needs and then the norms. So there are different ways to evaluate. Subjective assessment can be done. the data can be observed, collected, and then can be rigorously tested. And then the system can be run on experimental basis across space, across time, in different locations with different types of cases, with different categories of litigants, and then it could be decided. So subjective surveys based upon user interaction, the outcome, whether the users are really satisfied with the outcome, or they find it too efficient, but then still they have some fears because it is not fully transparent or it is not fully inclusive, those things have to be factored in. When we take up observational studies, we mean that we will take into account large data sets and then seek evidence consistent with casual inference, or whenever the evidence is available, is it really consistent with the inference given by the system? Or does the system give an inference irrespective of the quality of the input or the irrespective of the evidences being consistently being made available? Similar to randomized clinical trials, we can also run clinical trials across different jurisdictions, across different categories of cases, across different categories of stakeholders, so that the AI systems are evaluated something very similar to randomized control trials, but not identical to them. In such a case, there should also be a control group where we call within quote a placebo being offered to the people who are in the control groups. So, transposing the idea of randomized control trials to legal system development is a new idea, but then it could be done over a period of time with some restrictions and then some justifications. So what to evaluate? We need to evaluate when to evaluate, the target populations are ready, and then for RCTs we need to do a small statistically powerful user groups, a small test, so that you know that the same thing can be repeated when it is tried on large scale, and more importantly, the preliminary evidence should be able to tell us the problems with the system, the bugs that could be identified, or system coming up with fantastically correct answers but nonsensical. In the sense that when the same input is given on similar cases to a system, it should be, in the ideal case, able to come up with similar or identical outcomes for those cases. But if the system for some reason comes up with conviction in 40% cases and then acquittal in 60% cases, or a very similar outcome, then there is something fundamentally wrong. So we need to do such a pilot testing before going to RCTs. And more importantly, we should also be able to refine, redefine, and then scale up the system only when we are thoroughly convinced that system has worked and then it has been tested on solid evidence base. Or in other words, the statistical sample size might need to be increased from 500 to 1000, or from 20 to 50, or the statistical sample number may be the same, but then it should be made more representative so that the stakeholders' representation reflects the real world universe. Or in other words, evaluation of a system is something that needs to be done on a methodological basis on well cleared out, well understood methodologies. It cannot be a random one-time exercise. It has to be an exercise that should be based on science, statistics, and reasoning. So the potential benefits in AI and the concerns and all we have already seen. But one major thing is that we have talked about democratization, we have talked about all the benefits. The real risk is that AI legal services can result in a two-tiered system. Two-tiered system means that the poor may end up getting inferior, low-quality AI-based system, so advice and then information, whereas the rich, the powerful, those who could afford, may get sophisticated systems where the human lawyers will be deciding, human lawyers will be the ones who will be interacting, and then the human lawyers as well as AI-based systems, the powerful ones will be able to have access. So, large-scale deployment of AI in legal services can result in democratization, access to information, making consumers much more easily comfortable with those systems, but it can also create in a two-tiered system where legal aid, something through AI, is reserved or mostly utilized by poor who cannot otherwise afford access to high-quality legal service. When this happens, the real problem would be that those who need high quality legal advice and services are the poor, but then they may end up getting very poor quality service, or the AI quality service may be good enough for them, but not sufficient enough for them to win a case. Put it in other words, making AI in legal services available, easily accessible, does not mean that there should be a compromise in the quality of service. But question here is that can we really think of AI in legal service that is as good as the good or the expertise based law firms which have got access to all resources, and then the powerful and the rich will anyway have access to them. So in such a scenario, we need to be very cautious about claims that AI can democratize access and AI can result in personal access. So the current regulation issues in AI need to factor these things. But more importantly, what should be done and what could be done is something like develop AI systems to begin with. Make them more sophisticated, make them comparable with the best legal service, legal advice available over a period of years as a pro bono public service institution, public service tool. When this is done, and then when the AI tools are as sophisticated as the ones used by the other powerful and rich people or the lawyers who they represent, then it will be easy to justify AI's extensive use in legal services. So what we are talking of here, to put it in a understandable term, is that equitable access to legal AI. Equitable access to legal AI can be demanded because it is something that should be demanded as a right when AI is going to play a major role in law and justice. So the AI tools have to be tailor-made for this sort of equitable legal AI, and there are barriers like insufficient resources, lack of expertise, and then weak resilience and all. Then there are a whole question of regulatory reforms and all, but if we want to foster legal AI access, then there should be a framework for equitable legal AI access. We cannot talk in terms of mere legal AI access if we want to really bring in a change. Otherwise, in the absence of equitable legal AI access, whatever the changes that are brought in may not help those who really need them most. But the technological innovations in legal problem solving can be expanded both in terms of quantity as well as quality, and then in terms of diversity and access. For example, free guides may be made available online. Legal service organizations can automate intake process or can make use to chatbots and then other materials or other mechanisms to have better interaction with clients. And enhancing legal literacy among the clients will be another option to do that. Similarly, for consumers, professional legal help should be easily available either through chatbots or through legal AI tools. And then the consumer should be really connected with the right legal service agencies or providers. For example, this itself can be done by a chatbot. When a chatbot query is put that I am a consumer facing an issue and I want to approach the consumer forum because the service given to me for a particular product was defective or the product was faulty, then that chatbot should be able to really identify the legal service provider who will be able to meet the need of the consumer. So we can think of multiple innovative and then relevant technological solutions for solving some such problems. Then in document automation, chatbots can play a major role because significant investment in technology has been done by many firms and then also by governments. Automated client intake can be done by major firms, even the judiciary can do it because they need to start a process where the client can need to type in details so that his or her address and other details are taken care of, and then the queries are put to as to what exactly is being needed. Then access to legal research tools can help them to put queries in natural language. For example, just as we converse, the queries can be put in. Is my claim time barred? Or is my claim not time barred, but is there sufficient time for me to file a case now or file a petition now to claim some benefits? Or some natural language queries like what is my right in such a situation where my client has gone to encash a check but it has bounced back, and then repeatedly it is happening to my client from the same party. Similarly, certain query based can be transferred to frequently asked questions so that clients need not again and again reach out to the chatbot to answer some basics. So efficient e-discovery process when machines can complete discovery faster and accurately, if that can be made part of public legal service of using AI or equitable AI tools, access to AI tools, then it will be easy for many people who otherwise cannot afford e-discovery services to approach the courts with more confidence. So what we are saying is that document automation and chatbots should be part and parcel of equitable AI access programs to be offered by courts and other legal service authorities. Then we have discussed about predictive coding and legal analytics. We have also discussed about the future of legal problem solving where it is going to be increasingly data driven. But there are some major issues which are real constraints. First of all, the increased reliance in AI driven legal services can result in some sort of diminishing in people applying their brain towards legal services or using their capacity to understand and then take a decision. Instead, they may simply say that AI tools are available, AI based legal services available, we should approach it, instead of even thinking as to whether it's the first place they should go for such a course or not. Then, superior human lawyers will always be able to outwit whether inferior or superior AI assistants. Then AI superiority may come, but then it would be expensive or unaffordable, or AI superiority may be very superficial because in reality the system may not be all that perfect. More importantly, affordability is not a question of technology alone. Affordability is also a question of cost. Affordability is also a question of language and culture. Affordability is also a question of people having the trust and confidence to approach the institutions. So we cannot reduce each and everything to mere technical solutions. And more importantly, AI cannot be a panacea for all the issues in equitable access to law and justice. So access to justice gap can be filled up through AI because the access to justice gap is widening on account of various factors. So calibrating AI usage in specific contexts can help in that. More importantly, how AI should be calibrated is thing that needs to be deliberated upon. So AI calibration should be very effective. It should be undertaken as a ongoing process, and then integrating this calibration into the broad AI integration to the law and justice is equally important. So the policy priorities and then the regulatory reforms have to be identified so that they become part of addressing the issues in justice gap. Then there are costs like high costs, social disparities, lack of knowledge, limited English proficiency, and language and cultural barriers. But this justice gap is not something that affects USA or India or any country. It's a global problem. So it needs to be addressed on a very different thinking. That thinking will be very simple. Think global, act local. Or think of the global in the sense that get a wider perspective and then look at specific tailor-made local specific solutions that can increase access, that can make equitable access in legal AI a reality. So when this happens, we need to also identify why the justice gap persists. One problem is that people get disengaged from legal systems for many reasons, including distrust, expensive, or they fear that legal systems may expose them to more risks. Or not all people really want to go to courts seeking solutions or seeking assistance. They think their lives will be better off if they do not approach the courts, even at the cost of they paying some price, or even if they forego some rights, or even if they forego some claims. So those gaps need to be addressed and then need to be identified, and then how technology can address them is a big question, but technology can be used to address some of those gaps. So what we are saying here is the justice gap, if need, has to be addressed by technological innovations including AI, then it has to be done with some sensitivity and then due respect to the wishes and needs of the people who otherwise are not able to access that. Or addressing justice gap is not a mere technical solution, it needs to be done much more than that. So I've highlighted some literature here, particularly the most recently available literature, but then again this is an emerging topic. Lots of new things are happening in it. So we need to keep our eyes and ears open to understand the developments. More importantly, the AI revolution in law is not going to end up soon. In fact, it has started on a full scale, not even now. But it is going to bring in enormous changes, many paradigm shifts, and then lots of transformations in terms of both structural matters as well as process matters. So, understanding how this the relationship between AI, law, and innovation in the context of justice or in the context of law is very important. In the next session, we will look into an interesting topic, AI, law, and justice beyond techno-solutionism. This session will be the session that will introduce you to the concept of techno-solutionism, and we will take forward some of the issues which we identified in this session in the next one. Thank you.